Thank you, Jim. I was just reflecting, talking about identities. It's so easy to create identities. You can now pigeonhole me as another one who has brought this dull and dismal weather from where I live. That's 3 of us now, isn't it? Perhaps that's the latest new identity. Well, good morning. Thank you, Alzheimer Europe, for bringing us all together here. Thank you for the planning and organization that's already delivering an excellent conference. Thank you for inviting Council of Europe to make a contribution. I'm delighted to have been asked to provide that contribution. My perspective, as Jim has said, is as an external consultant to the Council. I'll start with the broader context, then explain my particular role. And again, as Jim has said, my background is 50 years' experience as a working lawyer in the front line of dealing with the circumstances and needs of people with intellectual disabilities and those around them. Like such lawyers everywhere, I tried to do my best, but existing law was simply not good enough. So I became involved in campaigning for law reform, then achieving it, then trying to make it work in practice. Right now, these are exciting times. Now, more than ever before in my career, right across the world, we face collective challenges, challenges full of potential to make things better, encapsulated in the work of various international and European bodies. My own remit for Council of Europe includes referencing the work of other relevant international bodies, so I shall start with some of them. Current international trends have a common theme. This conference has the overriding theme of excellence in dementia research and care. We must be careful not to interpret that word care too narrowly. Are people with intellectual disabilities the objects of care, or are they the subjects of rights? Should we emphasize only the need to protect them, or also the need to enhance their autonomy? As lawyers, should we apply child law principles to them? Or should we be clear that they are not big children, but adults entitled to the full recognition of their rights, personality, and legal status as adults, even more strongly because of their disabilities, rather than less? In recent years, the emphasis has shifted towards autonomy, self-determination, the full recognition of rights, personality, and legal status. There is, of course, a danger if that shift is carried too far and too crudely. One form of discrimination is to refuse to acknowledge the existence of disabilities and their consequences. Simplistic theories suggesting that everyone, however great their intellectual disabilities, can fully act and decide for themselves if they're given enough support, ignores the realities of people such as those with advanced dementia and risks leaving them out in the cold. They are the people most deserving, not least deserving, of all the help that a legal system can give them. There are no real contradictions here. Excellent care can, indeed should, include the exercise of autonomy and self-determination to the greatest possible extent, at the same time ensuring that a person's rights and interests are fully protected in matters beyond the limits of their capabilities to act and decide for themselves, even with support. Crucially, however, if others have a role in this, that role must be centered upon all that can be understood and ascertained about what the individual would do and decide if capable of doing so. This, I would suggest, is the approach required by the UN Convention on the Rights of Persons with Disabilities, which has triggered welcome debate about how best to operationalize in practice the requirements and safeguards of that convention. Article 12.3 of the Convention requires states parties to take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. In the final report of the Essex Autonomy 3 Jurisdictions project, assessing compliance of the 3 United Kingdom jurisdictions with the Convention, we put the relevant question like this: what measures should be taken to support the exercise of legal capacity, both by supporting persons with disabilities to make decisions themselves wherever possible, and by supporting their ability to exercise their legal agency, even in circumstances where they lack the ability to make the requisite decisions themselves. Article 12.4 balances the maximization of autonomy with requirements for safeguards. The universality of human rights places upon all of us an obligation to take ownership of the task of finding ways to operationalize the requirements of the UN Convention in our own countries. Some criticism of the UN Committee on the Rights of Persons with Disabilities fails to understand that. Another concern is that increasingly across the world, people with Alzheimer's and other conditions that might affect their intellectual capabilities have assets and interests across borders. These matters are regulated by Hague Convention 35 on the international protection of adults. Disgracefully, only 9 countries have yet ratified it. All of them are European, but I suggest that those of you with any influence within states which have not yet ratified should urge ratification. The Legal Affairs Committee of the European Union is addressing these cross-border issues. The possibility of a European regulation is also to be encouraged. This brings me to the Council of Europe. It's the oldest European institution. It has 47 member states, far more than the European Union, and comprising every European state except Belarus. It is governed by its statute, which states that the aim of the Council is to achieve a greater unity between its members for the purpose of safeguarding and realizing the ideals and principles which are their common heritage and facilitating their economic and social progress. Its areas of operation are broadly stated to cover economic, social, cultural, scientific, legal, and administrative matters. Defense is excluded. 2 of the Council's oldest and greatest achievements, closely related to each other, remain unique in the world. These are the European Convention for the Protection of Human Rights and Fundamental Freedoms and the European Court of Human Rights. The Convention is unique because anyone, even non-Europeans, can seek redress from the Court, whose judgments are, again uniquely, binding upon any member state found to have violated Convention rights. Another Council of Europe convention of particular relevance for us here is the Convention on Human Rights and Biomedicine, also known as the Oviedo Convention. The committee appointed to draft the Oviedo Convention became a permanent committee on bioethics. In 2014, the committee issued a guide on the decision-making process regarding medical treatment in end-of-life situations. While time doesn't permit me to describe the contents of the Oviedo Convention and the guide, I would commend them both to this audience. The Council's decision-making body is the Committee of Ministers. One of its significant activities is to issue ministerial recommendations. These include Recommendation 1999-4 on principles concerning the legal protection of incapable adults, and Recommendation 2014-2 on the protection of human rights of older persons. they intersect in relation to older people with intellectual disabilities. The 2014 recommendation covers issues of non-discrimination, protection from violence and abuse, social protection and employment, a range of principles relating to health and care, and the administration of justice. In particular, it stresses the importance of personal dignity, self-determination, autonomy, the right to receive appropriate support, and the right to make provision for future incapability. For those not already familiar with it, I would commend the whole of the 1999 recommendation as being relevant to all interests represented in this conference. The status of the 1999 recommendation was emphasized by the European Court of Human Rights as potentially setting a common European standard. Principle 7 of the 1999 recommendation reads, "Consideration should be given to the need to provide for and regulate legal arrangements which a person who is still capable can take to provide for any subsequent incapacity." This leads to the ministerial recommendation with which I have a particular involvement, Recommendation 2009-11, on principles concerning continuing powers of attorney and advance directives for incapacity. I was a member of the working party which drafted it. Principle 1 speaks for itself. Firstly, states should promote self-determination for capable adults in the event of their future incapacity by means of continuing powers of attorney and advance directives. Secondly, in accordance with the principles of self-determination and subsidiarity, states should consider giving those methods priority over other methods of protection. Leading-edge practice, stimulated by the UN Convention, has already moved beyond a simple characterization of capable adults providing for incapacity. Increasingly, with appropriate support, adults with some degree of intellectual disability are granting powers of attorney. Most systems would regard such powers of attorney as valid if the grantor understands the basic concept and is able to select someone whom they would want to act for them, even if they understand that there are matters which need to be addressed which they are not themselves fully able to manage. Of course, in such situations, the requirements of Article 12.4 of the UN Convention for adequate safeguards, including against undue influence and conflicts of interest, are particularly important. Power of attorney documents for such use will generally be simple and basic in easy-to-read language. Further developments include the incorporation of supported decision-making and co-decision-making provisions in power of attorney documents. These recognize that relevant intellectual disabilities and capabilities are variable across a spectrum, variable in degree over time and as to particular matters. The role of chosen supporter can be valuable in the area in between full capability and significant incapability. It can morph when necessary from the role of a supporter to the grantor into the role of an attorney acting for the grantor. Likewise, under co-decision-making arrangements, a decision by the grantor and the attorney made jointly will always be valid if declared to be the grantor's own decision to the extent that the grantor is capable, and that of the attorney to the extent that the grantor is not. Self-determination in advance of need is much to the advantage of society as well as of the grantor. Some old-age psychiatrists in my home area expressed concerns to me about people stuck in hospital beds when they no longer needed to be there, and blocking beds required by others, because someone needed to be appointed, usually by court process, to make necessary decisions. I suggested how procedures could be accelerated, but commented that every power of attorney document granted with relevant powers would potentially mean one less such problem in future. That comment was picked up by Jill Carson of Greater Glasgow and Clyde Health Board, who's here to tell the story later today of how the savings to public funds in having more attorneys available to make prompt decisions has fully justified the cost of a repeated television advertising campaign encouraging people to consider making powers of attorney. The clear human rights advantages of what we call autonomous measures, including both powers of attorney and advance directives, led to my own current role with Council of Europe. The Council decided that one of the many ministerial recommendations should be selected for a review of implementation. The Council's Committee on Legal Cooperation selected the 2009 recommendation, and that was included in the programme of work for 2016 and 2017 approved by the Committee of Ministers. I was appointed to carry out the review. What am I doing, and how am I doing it? The starting point was, of course, the recommendation itself. I went through the recommendation principle by principle and drafted a questionnaire designed to obtain the information needed to find out how each member state is getting on with implementing the recommendation. But that caused a problem, which I discussed with the Committee on Legal Cooperation. We could see that enthusiastic respondents with sufficient time would be happy to provide a wealth of helpful information in reply to all of my questions. However, we didn't want to find that some would be daunted by the length of the questionnaire and not respond at all. So we produced two questionnaires, a shorter one and a longer one. The longer one is optional. In accordance with the principles of openness, all this documentation is available on the Council of Europe website. I have to say that although we asked that responses to the questionnaire be sent in by the end of September, some responses continue to come in, and we have received friendly assurances from overloaded officials in various justice ministries across Europe that they are working on the questionnaires and will respond soon. I shall be here to participate for the full duration of this conference, but as soon as I go home, I'll start my next task, which is to prepare a first draft of a report, drawing on all of the information which we've received. In the first instance, that will go to the Committee on Legal Cooperation. The timing means that I can't give you any preview of the picture which will emerge as regards both powers of attorney and advance directives from across Europe. But I shall not be surprised if a patchy and variable picture of implementation emerges. I shall look in particular for lessons to be learned from how states balance maximizing autonomy with necessary safeguards. Grantors may be vulnerable to undue influence when granting these documents. They're likely to be vulnerable to abuse when their capabilities are impaired and powers are being exercised. The Council of Europe is above all there for all the citizens of Europe. It is my hope and belief that by cooperating in this review process, member states will enable us to form an overview of what works best for their citizens and lessons to be shared for the benefit of all of us. Perhaps over the next few days, I shall pick up from at least some of you a citizen's view of how such arrangements are working across our continent and how they might work better. Thank you for listening to me.